everybody. My name is Shauna McEachran, and I'm an occupational therapist, and I'm what's called a designated capacity assessor. So that's a lot of words, but my job is to talk to people about making decisions. And so the law tells us that every adult is responsible and has the right to make their own decisions as long as they can understand the facts about what's going on in their situation, and as long as they can appreciate the options, appreciate the pros and the cons, or the risks and the benefits of their choices. So today I'm going to focus on the financial side of things with the potential for abuse and how to prevent that, and who's allowed to make decisions about money and finances and property when somebody can't. So I've provided my contact information for people. I'm very happy to consult on cases, to talk to people about cases, and even in very general, generic terms. So I've provided that for you to be able to help with some system navigation. So first of all, what is a designated capacity assessor? So a capacity assessor is a healthcare professional who's been qualified as a healthcare professional, but then trained on top of that by the Ministry of the Attorney General and the Capacity Assessment Office. And there are certain jobs that only we are allowed to do. And so we are governed by the Substitute Decisions Act. So legislation, law that has outlined how it is that people would make decisions if somebody is not capable of making them themselves. So designated capacity assessors can be doctors, they can be nurses, they can be social workers, occupational therapists, any of the registered health professional, regulated health professionals, except for physiotherapists. And the physiotherapists got left out, but basically the rest of the regulated health professionals can do the capacity assessments with the training. And so we've all completed this training. We have there's requirements for us to submit reports every couple of years and to do different quality assurance things to make sure we're doing them correctly. Capacity assessments at this point in time are not covered by OHIP. And so that's probably one of the biggest barriers to people accessing capacity assessments. Most times they are paid for by the client or the family who's seeking the assessment. In general terms, the person or people who've asked for the assessment are typically the ones expected to pay for the assessment. And so there's distinct and separate types of capacity assessments. And that's probably the part that's least understood by people, is that a capacity assessment for property, which is money, is different from a capacity assessment for personal care. It's different from a capacity assessment to grant powers of attorney. It's different from a capacity assessment to do a will. And so it's often hard for people to understand because they call and say, I need a capacity assessment. And the very first question for me is, for what? What are we trying to assess? What are we trying to do? Because capacity is situation and decision specific. It's not one umbrella that covers every situation. So in general terms, when I'm talking about a capacity assessment for property, we're looking at about in the $1,000 range to do a capacity assessment for property. There's some monies available for low-income people. The Capacity Assessment Office, through the Public Guardian, they do have some funds available for people on fixed incomes. So people on ODSP, people on GIS or guaranteed income, they can qualify usually for a subsidy to be able to get a capacity assessment. But the Capacity Assessment Office only subsidizes assessments for property management, for financial management, where the Office of the Public Guardian and Trustee is being asked to take over to manage someone's finances on their behalf. Okay, so there's rules, there's regulations, but just to know that there is a little bit of money out there for certain types of assessments. The legislation that we work under as capacity assessors is called the Substitute Decisions Act. And this is it's a legal test. And so one of the questions that often comes up is the difference between a medical capacity assessment and a legal capacity assessment. So as a designated capacity assessor, I do legal assessments. And so capacity is the ability to make a decision. So it's not function. It's not about whether someone can go to the bank or can count their money or can balance their checkbook. It's about, can they learn how to do different things in order to make an informed choice, in order to make an informed decision about what it is. Consent, on the other hand, is giving permission or agreement to a decision. And informed consent is more of our medical jargon. So informed consent is when the doctors, the nurses, the therapists have to give somebody the information about the risks, the benefits, why are we recommending this, and somebody is agreeing to it with full understanding of what those possible consequences are. So informed consent is a medical model. Capacity and consent tends to be more of a legal statute. So when we're thinking about elder abuse, there are kind of three main categories that I look at when I'm thinking about elder abuse. So the first one is, who has the authority to make the decisions about money and property? And you'll notice property is the official language. I find a lot of people get confused when I say property and think real estate. So I will use finances, money, property interchangeably. They all mean the same thing. So the first question for me is, who has the actual authority to make the decisions? The next question is, when are they allowed to act? Who's allowed to act in what circumstances? Under what circumstances are they allowed to do that? And what are they actually allowed to do or not allowed to do? Because these are all very confusing factors, and people don't always understand what their role is. So who makes money decisions? So there's really only three choices. When we're talking about decisions about money, there are only three options in our law for who can make the decisions. The first one is the client. Clearly, you and I, being capable people, we are independent, we are directing our own financial affairs. Even if we're not doing it all ourselves, we can delegate. A capable person can delegate. So a capable person can say, I don't understand anything about mutual funds, I want the guy at the bank to do it. Okay? And you can be capable because you've recognized your own limitations and you've arranged for someone else to do it. So the client is always the first stop. The client is presumed to be able to do it until we have solid evidence that they can't, until we have solid evidence that they aren't able to. The second person who can manage money is the power of attorney for property. So this is a delegation. So this is me as the client saying to someone that I might not be able to do this at some point, and if I can't manage my money, if I can't manage my property, I trust you to do this on my behalf. Okay, so this is the client still in control because the client's making the choice and they're delegating to someone. The third one is a guardianship, and guardianship is a last resort. We only do a guardianship when there's no other options available, because with a guardianship, someone else decides. Okay, so it's no longer the client deciding about who manages their money, it's some other person, whether it's me as a capacity assessor, whether it's a family member or a court or a judge, somebody else is making the decision about who will manage their money. And so you can see that there's some important decision points here, because as a last resort, if the client can't manage their money and there's no power of attorney, the only other option is a guardian, because there's nobody else allowed. Okay, there are no other circumstances where somebody else is allowed to do it. So I love this lady. She is classic. You're going to see her throughout my the thing. So yeah, so lots of people say, oh, I manage my own money, and for her, she manages to spend it all. Okay, and that's fine if somebody's making an informed choice and a cognitive decision to spend all their money. They're allowed to do that, right? As long as they understand the consequences, as long as they understand the risks, that's perfectly acceptable. So my job isn't to see whether they're making reasonable decisions, because I might not agree with their decision, but are they reasoning it through? Are they thinking it through, and are they considering what the problems and the potential risks are? So we in Ontario have a presumption of capacity. So everybody, once they hit, for property matters, is 18. So once somebody hits age 18, they are presumed to be capable of managing their finances. The only time we can override that is if there's a clear path, a clear line of evidence that shows that somebody's not understanding or appreciating. So there's no upper age limit. So I'm just going to highlight that for the seniors. There's no upper age limit that says, when you hit age such and such, we cut you off. That does not happen. There are 105-year-olds who are still capable of managing their own money and do. There are 30-year-olds who are not capable of managing their own money and don't. Okay, so there's no age limit associated with it. The other thing about capacity that's important to notice is that it's not a diagnosis. It's not, we can't use screening tools or cognitive assessments in order to determine capacity. So you'll hear lots about a MOCA, which is a Montreal Cognitive Assessment, or a mini mental status exam. These are commonly used screening tools, but they're screening tools for cognitive impairment. They are not screening tools for capacity. Okay, and somebody can do very poorly on a screening tool for cognitive issues and still be quite capable of understanding and appreciating. So just because somebody has a score on a test or because they have a diagnosis, just because someone has dementia, we all know that dementia can be, I can't find my keys, or dementia can be, I don't know who any of my family members are or where I am, right? So there's this huge range. Schizophrenia, stroke, mental illness, all of the diagnoses, they're an indicator, they're a flag, but they are not an indicator of capacity in and of themselves. They're only one piece of the puzzle. So it's incorrect for people to assume that just because, and I can't tell you the number of times where people call me and say, well, mom's incapable, she was diagnosed with dementia in 2020. No, that does not mean she's incapable, that means she has dementia. And so important to notice that there is a difference between the two. So when I'm looking for incapacity, what am I looking for? So I'm looking for things like impaired memory. If somebody can't remember what they did yesterday, or they can't remember whether they paid the hydro bill, or they can't remember when the rent's due, then they may not be able to make good decisions. Okay? They may not have good insight. So lots of seniors with dementia will say to you, oh, I'm perfectly fine, dear, everything's wonderful. And their daughter and their son are sitting behind them going, no, that's not true. Okay, so limited insight is they have issues, they don't recognize they have issues. Poor problem solving might be just that overwhelmed. There's just so many things to think about. There's so many issues. It's so complicated, they just can't put it all together. So they might not have good problem solving skills. Somebody might have limited cognition. So they might have a pre-existing, somebody with a developmental delay, somebody who's had a brain injury, someone who's had a stroke that's affected their cognition. They might not have the intelligence to do some of these things. So that may be an issue. Someone may have limited communication, and I'll caution you on limited communication because this is not a be-all and end-all. Just because someone can't talk the way you and I are talking does not mean they are or they aren't capable. If someone can communicate with technology, or if they can communicate with a pen and paper, even if they can just communicate with nods and shakes of their head, they may still be able to communicate their intention and what it is they want. And so if someone has no ability to communicate, then they may be incapable. Poor reasoning. So reasoning is kind of that overarching thing where we're trying to come up with, well, why? So people sometimes get a bit frustrated with me because my favorite question is why? So why do you do that? Why do you think that? Why are you trying to do it this way? Because I'm looking for, can they actually explain to me the why of why they did that? And if they can explain to me why, and it's a reasonable, then that's capacity. Impulsivity tends to be more of an issue with our mental health population or developmentally delayed, where they don't think, they just act, right? So they might see, I've had a number of clients who just love the shopping channel. So they see it come on the shopping channel, they want it, they need it, they buy it. And they don't pay attention to, oh, I didn't actually have enough money for that, or now I can't buy the rent or buy my food, but they're impulsive, so they just do things without thinking. They may be disoriented. So if somebody thinks it's 1965 and their bill is due in 2022, they're probably going to have a bit of trouble deciding when to pay that bill. Okay, so that might be a classic sign. Disorganized thinking, delusions and hallucinations, we would get into with some of the frontal lobe dementias. So if people are having delusions or they're having hallucinations, They can't tell reality from truth, so that it's hard to make a decision. It's hard to make a decision if you think something's going on that really isn't, okay? So I had a classic one of that. I had a gentleman who I arrived, and he was determined that he needed to go to the bank, and he was absolutely beside himself that he needed to go to the bank. And when I probed why he wanted to go to the bank, he told me this wonderful story. He was in hospital, and he told me this wonderful story of how he and a nurse had snuck out of the hospital the night before, and they'd taken a bus to the brothel. And in the brothel, there was a bar fight, and the nurse got hit in the head with a beer bottle. So he needed to go to the bank to get money to pay for the lawyer for the nurse to do this. Okay, clearly none of that happened, okay? But he believed it. He believed that that was what happened. So I found him incapable because he couldn't decision make in a reality-based fashion. Concrete thinking, that's when somebody has very black and white thinking. They can't see those shades of gray. So it's either a yes or no. And poor judgment, generally, just making poor choices, making poor judgment without appreciating the consequences. So these are the types of things that I'm looking for when I'm talking to somebody. When I'm doing an assessment, I'm looking for all these signs and all these indicators to try and tell me whether this person has some red flags. So, and when I'm looking at them, I'm looking under this definition. So all capacity assessments follow the same definition. So a person who's capable has to have the ability to understand. So they've got to be able to understand the facts about what's going on. And they have to have the ability. The ability is important because ability is that can you learn something? So a woman who's been widowed, whose husband has managed her financial affairs for their entire life, and she's now widowed and doesn't know how to do it, I have to sort out, does she have the ability to learn that? Or is she really truly not able to learn that at this point? Or is she not willing to learn that at this point? Okay, because there's a difference between I don't have the information and I can't learn the information. Okay, so I have to sort between those two. I also have to look at whether they can appreciate the consequences of their choices, appreciate the consequences of their actions or their lack of actions. So somebody might make a decision not to pay the Bell Canada bill because they disagree with it. They think that the bill should be a different amount. So they might make a decision not to pay it, but that decision is going to have consequences. So I'm going to be probing, do you understand what the consequences are if you don't pay that Bell bill for the next 2, 3, 4, 5, 6 months? What's actually going to happen? It's okay that you don't agree with them, but your phone's probably still going to get cut off. Okay, so we need to find another way to try and deal with that. And people have the right to make bad decisions. Okay, we all make bad decisions. We drive a little too fast and we know we could get a ticket, but we do it anyway, right? So people have the right to make bad decisions and we have to respect that they have the right to do that. A fool and his money can throw a hell of a party, right? So if we have bad decisions and we decide to blow $10,000 on something, so we see this a lot with gambling, with addictions, with alcohol. People make decisions to behave in a certain way, and they have consequences. And so we have to sort out what is the difference between not knowing and not caring, okay? So if the client can't make the decisions, so the client with all those things that they have to have, so they're presumed to be capable. If we have the evidence that they have some of these other things, then we could suggest that they're not capable. If they're not capable, then we're looking to a continuing power of attorney. And I believe there was already another presentation on that. But basically, a continuing power of attorney for property is a grantor, a client giving permission, giving consent for another person to manage their affairs. And they are giving them the keys to the vault, okay? So it has to be someone that is very trusted, who's good with money, who makes sound financial decisions themselves, because they are stepping into that incapable person's shoes. And they can do anything that the capable person would normally do. The only thing they can't do is write a will. So I'm the only person that can write my will ever. But once I assign a power of attorney, whoever my attorney is can go to the bank. They can sell my house. They can sell my car. They can sign me up for credit cards. They can get a Bell Canada account in my name. Okay, so they can do anything I can do except write a will. So it's really important that we make sure we're choosing the right person. So power of dad still trumps the power of attorney. So again, I'm going to bring people around to, I have lots of people who come in and say, you need to talk to me because I'm the power of attorney. Okay, but we only talk to the power of attorney if dad or mom can't talk to us, if they don't understand or appreciate. So a power of attorney for finances, they have no authority until or unless someone is incapable of making their own decisions. So there's got to be some evidence. There's got to be something that says that they're not able to do it. Now, there are some legal loopholes that I'm not going to get into here as far as general powers of attorney and different types of things. But essentially, it's important to know that you're really giving somebody a lot of control and a lot of power. So there's a few things that people can do to protect themselves when they're looking at a power of attorney. So all families are made a little bit differently. So there's families with lots of children, there's families with very few children, there's families with no children. Who do we get to make these sort of decisions if we can't? And so there are a few things that can either trigger or delay when a power of attorney can act. And this is really important because power of attorney documents, they're not all standardized, right? There's some that you can get the kits online or you can get the kits at the ministry office and fill out. There's some from lawyers. They're done by all sorts of different lawyers. The wording is a little different each time. So you really have to delve into that document and actually read the document to know who's allowed to work and who's allowed to do it when. Okay, so some documents actually have an effectiveness clause in them. The majority say this document comes into effect as of the date of signing. So for most people, if you signed your power of attorney document in 2015, it's been in effect since 2015. Anybody can use it at any point. Lots of times families do that because it's easy, right? If you really trust the person who's not going to just barge in and take over, then that's a perfectly valid way to do it. To say, this is in effect now, but I trust you not to overstep your bounds. The other way to do it is to put a clause in it that says, okay, this is not in effect now. This comes into effect at some point in the future. And so usually that is something like when 2 doctors find me to be incapable, or when a designated capacity assessor finds me to be incapable. This is getting a little harder for people to do because doctors are getting less and less willing to assess capacity to do finances. And that's partly because it's a legal test. It's not a medical test. So they've got the skills as far as doing the insight and cognition and orientation, but to move that into the legal definition and the legal context, a lot of doctors shy away from that. So unless they've had additional training in it, they tend not to do it. And so if there's no way to meet the clause, so there's a lot of these documents around from 20 years ago, and some of them have been way too specific. So some of them say, you can use my power of attorney document when Dr. Smith says I'm incapable. Well, Dr. Smith's long retired. He's moved to Timbuktu. We can't have Dr. Smith assess. So if the clause can't be met, then it falls to a designated capacity assessor. And we're the only ones that can then activate that attorney. The other thing that's happening a lot with these is that even when they say this document comes into effect now, the banks are really covering their bottoms as far as whether they will accept those documents. So although you may have a perfectly legal document, you may have done everything exactly right, if you go into the bank today and try to use that power of attorney, the banks are doing their due diligence and they're asking for capacity assessments in order to see whether the client needs it to be used today, okay? Because there's a difference between do you need it or is the power of attorney just going and doing it of their own accord? And this is because abuse is rampant. It's because there's lots of cases where attorneys are taking their documents in and they're abusing the privilege. They're moving the money, they're taking the money, they're not letting the senior have the money. So there's a whole range of different things that are happening that are making the banks really scrutinize these documents. The other place that they're really being scrutinized just more recently is Revenue Canada and Service Ontario. So for trusteeships, for transferring pensions, so to sort of move pension from mom's bank account to daughter's bank account, the Revenue Canada and the Service Ontario are now requiring power of attorney documents from a lawyer. They won't even accept the kits anymore. They want it from a lawyer because they want that independent third party who's reviewed this with them and said, yes, this is a valid legal document. The client knew what they were doing when they signed it. The problem being that the kits that we can get at Service Ontario that are in lots of offices, you can sit down at the kitchen table and you can do those, but there's nobody actually policing whether the client was capable at the time they signed it. And frankly, I can get someone to sign anything, right? So if I can get, as a stranger, if I can get someone to sign anything, you can imagine the pull or the clout a family member might have, especially if there's any verbal abuse, if there's emotional abuse, if there's neglect. There's all sorts of pull that family members can have to bully their family member into signing. And so these agencies now are getting more and more risk adverse because without a lawyer or somebody going over that document with them, they don't know the circumstances under which it was signed. And so it's getting harder for the people who are doing it right. It's getting harder for the people who are doing it properly, but it's protecting the people who are being abused. So it's a bit of a double-edged sword. So choosing a power of attorney is a choice, okay? People don't have to choose a power of attorney. And so giving a power of attorney, it is a very serious matter because we're giving them the keys to the vault. We're giving them access to everything. In some of the literature, it's been described as a license to steal. You are giving permission to someone to use your money and you're saying, I trust you. And sometimes trust is misplaced. Money makes people do terrible things, things that you would never expect them to do, that you would never imagine that they would do. So it's really important for us as professionals and for family members and others to make sure that when somebody is appointing a power of attorney, that it's their idea, that they're doing it of their own free will. I see a lot of cases where mom gets taken into the lawyer's office and daughter or son tells the lawyer, mom wants to change her power of attorney. Well, what does mom have to say? Oh, whatever she says. No, that's not capacity. That's not her idea. That's somebody else has planted the idea. Somebody else has suggested it. And we need to be clear that, is this what she really wants or he really wants? And so lots of sort of thinking about when we do a power of attorney, is that actually something that we want to do? So the most stress is caused by three things: money, family, and family with no money. Or family with money, actually. It could go the other way too. Because yes, money does make people do very strange things. And so we have to be really careful about that. So I'm going to make you guys think for a moment. Can you think of reasons why we might choose a power of attorney? When might it be a good idea, or under what circumstances might we think a power of attorney document would work for us?
When we leave the country.
Okay, yeah, so that might be a very time-limited or a very specific power of attorney document. Good, yeah, good. Any other thoughts?
When we have a family history of dementia and you anticipate becoming demented yourself.
Good, good.
So medical issues.
Yeah, if there's some red flags or some risk factors there, that would be a good idea. Any other thoughts, ladies?
Mine was just going to be for medical reasons, like if it's diagnosis is absolute.
Okay, all right, good. So my reasons for someone choosing a power of attorney are a little broader than that, because I look at a power of attorney as an insurance policy. It's something that I hope I will never need, But if anything should happen to me, I want to make sure that it's in place. Because right now, today, I'm capable, I think. So, but if I was to walk out and get in a car accident, I don't have anybody to manage my money moving forward. And so it doesn't matter that I haven't been diagnosed with dementia or I haven't been diagnosed with a stroke. Anybody can become incapable with any sort of accident. I could slip and fall in the rain and the leaves and hit my head, and I could be incapable. So a power of attorney document to me is my authority to choose, while I'm still capable, to say, if anything should happen to me, these are the people I want to work for me. The other big reason people choose a power of attorney is because they don't want the government to get their little mitts on their money, okay? Because the next step, the guardianship, may be the government, okay? So if people don't want the government, a power of attorney is their way to choose someone else. I suggest to people always, when you're young and healthy is actually when you do want to do your power of attorney. So that's the best time to be doing it. And when you want to be in control of who makes the decisions and you want to name alternates or you want to name successors. So a power of attorney document is sort of an ultimate issue of control, that I'm in control right now, someday I might not be, and so I would have someone else do it for me. When might we not want a power of attorney for property?
When you don't have a trustworthy person in your life.
Good, excellent, yes, good. Any other thoughts?
When you don't need it. When you're perfectly capable.
Okay, and what if you slip on the leaves and hit your head and you're in a coma tomorrow?
You might be careful.
Okay, so let's talk about insight. Okay, so first one right off the top, yes. If you don't have anybody that you can trust in this role, then clearly choosing a power of attorney, we don't want someone to choose a power of attorney because they have no one else, right? We don't want you choosing the, well, if I have to, I will take him or her, okay? If someone has no savings or very little savings, they have only very basic income, they're living off very basic pensions, they may not need a power of attorney, because if there's no house, if there's no car, if there's nothing except Canada Pension and old age security coming in, and they're living in a nursing home and that takes all the money, there's probably no need for a power of attorney because everything just goes automatic and direct. Some people don't do a power of attorney because they're afraid of causing arguments. They're afraid of causing family issues within the, because if you've got 6 kids and you have to choose 1 or 2, that may cause some arguments. They may have a fear of being labeled or of losing control. So power of attorney documents are not well understood. So they may have a fear of that, and they may have a fear of being taken advantage financially, so with no one to trust. So things to consider when we're picking out a power of attorney, we want to consider, is that person that you're considering, are they bossy and controlling? Because if they're bossy and controlling today, chances are when you're not capable, they're going to be more bossy and controlling. So you want to be careful of that. Is there a history of family dispute, family rivalry, family disagreements? Because those only get amplified as soon as we add money, right? So if you've got the estranged daughter who doesn't like her siblings, she's liable to come back as soon as there's money involved. Will some family members feel upset or left out? So sometimes people choose multiple powers of attorney. Like you can choose more than one person to act together in order to safeguard and in order to do things. If someone is being pressured to that power of attorney, we don't want to deal with that. We don't want to be looking at someone being pressured to do it. And we don't want to cause a fight. So is it necessary? No. Is it recommended? It's a careful consideration, and it's a consideration that each individual needs to make. The problem is there's no legal backup. So once you've gone through the client can't do it, and there's no power of attorney, that leaves us with the last resort, and the last resort is the government or a guardian being appointed to do it. So again, I note here that to me, this is like an insurance policy, that if you want to be in charge, then you do it. And dealing in elder abuse, working in elder abuse, you've all seen it. Nothing tears families apart quicker than arguments over money. So if you are unable to speak for yourself, if you're in hospital, if you're sick, your family may have access to your savings. They may be able to sell your property. I meet an awful lot of people who have been sick, ended up in the nursing home, only to come around and find that their house has been sold. Okay, and in some cases, that might have been the reasonable, proper thing to do. In other cases, it was really rushed and it maybe wasn't necessary yet to sell the house. So having someone who will really respect your wishes is important. So when can somebody do a power of attorney? I think there was a whole session on this. I won't go through this in detail, but basically a person has to be capable of understanding what a power of attorney document is, and they have to be capable of understanding what they have that needs to be managed. So they have to have a general idea of what their assets are, of what their financial situation is. They don't need to know the details at this point, but they need to know, I own a house in Washago, I have bank accounts at the TD, I have some savings with Manulife Trust. Okay, so they need to know the basics of what they've got. They need to know if they have any dependents. So for most of our clients, they're seniors, most of them don't have dependents, but there may be a disabled child that they have to look after. They need to know that this person they're choosing can step into their shoes and do anything except write a will. So they've got to really understand that here's the bank account, here's my bank card, here's my checkbook, here's everything, you manage it for me. They need to understand that's what's happening. They also need to understand that the attorney is responsible for a few things. The attorney is responsible to keep records. So I meet a lot of people who say, yes, my son or my daughter's managing my money, but they won't give me any bank statements. They won't give me my bills. They've taken my mail. An attorney doesn't have the authority to do those things, okay? And it's really misunderstood. The role of the attorney is quite misunderstood, but the legalities is that attorney has responsibilities to communicate with the person, to involve them to the maximum extent possible, to talk to them about the decisions. They have the responsibility to manage the money for the interest of the person, of the grantor who owns it. It's not their money to take a trip to Florida. It's not their money to pay off their mortgage. It's mom or dad's money, and it's to be used for mom and dad's best interest. And somebody needs to really understand there's a risk. This is a risk when we choose a power of attorney. And so when I'm looking at whether someone can grant the power of attorney, we're talking about risk. So how do we protect ourselves? So there's all these issues, there's all these competing thoughts that, well, we should have it, but maybe we don't, and can we trust somebody or can't we trust somebody? So how do we protect ourselves more with a power of attorney? So we can pick 2 or more people to act together. If we think that that's safer than having one acting alone, we can say, my daughter Susie and my daughter Jane, they need to act together, so they both need to sign. They both need to agree before we can do anything. So that may mean Susie can't go rogue or Jane can't go rogue, and so there's a little more protection. You may appoint several people to act individually or jointly with a voting mechanism of sorts. So maybe they name 3 children, and if these 2 can't agree, then this one's the tiebreaker. Okay, and it doesn't have, I'm using children as an example. It doesn't have to be children. It can be your brother, your sister, it can be your neighbor, it can be your pastor, it can be whoever you want. And so you can do that. You can add those sort of clauses to consider things like geography. You need to consider the family dynamics when you're doing that. But at the end of the day, you need to have those trusted people to be able to say, oh, wait a minute, we're not letting Johnny sell the house because the other siblings don't agree, and that's not what mom wanted. So we need to have that extra protection. So we can put those clauses in power of attorney documents. So your off-the-shelf kit that we get just at the office, it doesn't have all these things detailed. You can add it, but it's not automatic. The ones that are just off the shelf are automatic, say jointly and severally. And jointly and severally means either you or you can do things. not both of you together. Jointly is both of you together. And so again, reading the document and understanding the language is really important. So going home and looking at your own documents to say, who makes the decisions? Is it one person? Is it one or the other? Or is it two together, or three together, or four together? People can go overboard. Do not ever put, I want my 6 children to decide together. It won't happen. Okay. Now, again, there's a tiebreaker mechanism in the legislation that would deal with that. If 6 kids are supposed to decide together and they can't, the public guardian and trustee will actually end up making the decision. But again, that's the government now getting involved, where we're hoping to keep the government out. Choosing an alternate, same thing. If power of attorney A is in England and power of attorney B is in Australia, you probably want somebody around here who can sort of take the control and take the reins for now. And we need to look at these and we need to update these. So a power of attorney document that you did 20 years ago may not be appropriate today. So we need to make sure we're looking at them, I suggest to people every 5 years or so, because children grow up and move away, and then there's grandchildren, and there's all different sort of relationships. One may have moved far away and you haven't seen them for years, right? So updating them on a regular basis is always a good idea. Also, being careful that you're not just naming husband for wife, wife for husband. Because what we find a lot is by the time one or the other wants it, they may both be marginally not capable. And if there's nobody alternate, then we're stopped. We're absolutely done. So if the person can't act in their power of attorney, now we're back to the guardianship. We're back to having to go with the power of attorney's void because neither husband or wife can do it, and there's nobody else named. If your power of attorney for property is acting inappropriately, what can you do? So the first thing that I do as a capacity assessor is try to educate that attorney about what their job actually is. And so when I'm doing assessments about whether somebody can name a power of attorney or whether whether it's family members who are wanting to activate a power of attorney, it's important they know what their responsibilities are and their jobs are. And this is legislated. It's written out in black and white. The problem is that not many people actually read it. And so making sure they know what their job is, making sure they understand their responsibilities. There are mandatory reporting in nursing homes and in retirement homes. If it's suspected that there's financial abuse going on, it's mandatory for it to be reported. It's not mandatory in the community, but so we have to be a little more creative and careful in the community with getting people to give consent if they want us to look into it. And really important that people report thefts, forgeries, money that's gone missing, things that have been happening that are inappropriate. And the sooner the better, because it's hard to go back in. Once the money's gone, often the money's gone. And so the sooner things are recognized and the sooner things are reported to the authorities, the better, before it's all spent. So I like this one. So yeah, probably not capable at this point. If she wants to give the power of attorney to the cat, maybe not the best decision. So we'd have to explore that a little bit further. So last resort. This is the guardian. And so this is where I get more involved. So this is where, in order to get a guardian, you have to have an assessment by a designated capacity assessor. There's no pass and go, there's no $200. You pay and have a capacity assessment done in order to get a guardian. And there's two ways with some variation. So the first way is the Office of the Public Guardian and Trustee. So they're government agency, they are people sitting at desks in Toronto and Sudbury and Ottawa who have a file number and bank statements, and that's about all they know about a person. But they're making decisions about their money and how to do things. And they have 1,000 people on their caseload. So you are a number and you don't get a lot of individual attention, but they serve a purpose, because if somebody has nobody to manage their money, the public guardian and trustee is the place to go. So they will be, the public guardian will be their guardian for people who are incapable, is the first criteria. So that's my assessment, and don't have any alternatives. Family or close friends, though, can also apply to become the guardian. And there's two ways to do that. The most common way is to go to court. The most common way is for family or friends to get a lawyer, say, Mom's not able to look after her affairs, she doesn't have a power of attorney, I'd like to become her guardian. And this is most easily, I think, explained if you think about guardianship for children, for minors. A minor has to have an adult who is responsible to manage their money. It works the same for a senior in that a guardian is now in charge. They are in control. They are making all the choices and the decisions. And they can include mom or dad, and they need to try and include them. But at the end of the day, the buck stops at the guardian, that they are the one now responsible to make sure everything's done properly. And so a client under guardianship, their rights are taken away to manage their money. They're no longer allowed to apply for credit cards. They're no longer allowed to go to the bank and get bank statements. They're no longer allowed to get a Bell Canada bill. They have to have permission from their guardian. Okay, so it's really restrictive, and that's why it's a last resort, that we only do this if we really have to and if it's really necessary. They do have the right to participate, so just that's often misunderstood. So when we believe that there's a person who's mentally incapable, when we believe that there's a risk that they're suffering adverse effects, whether their money is being stolen or whether they can't pay the rent and they're about to be evicted, whether they can't pay for their food, guardianship investigations is a branch of the Office of the Public Guardian and Trustee. And so they will investigate situations where you find somebody in the community who you know is not doing well, but has nobody helping them out, isn't able to kind of do it themselves. And so they will look into, has the money gone missing from the bank account? Are they going to get evicted? Can we stop that? Is Revenue Canada coming after them for back taxes, and can we fix that? Are creditors coming after them? So lots of people we get have got thousands and thousands of dollars in debt, and the bank may be going to foreclose, or they've gone to a collections agency and they're getting letters and calls all the time. So guardianship investigations is a really useful place to get in touch with if you know you've got someone that needs the help, but they don't have anybody to do it for them. That is useful to get them on to guardian. So the role of guardianship investigation is probably to get somebody a guardian. Okay, so this is that last resort. The other mechanism is if somebody has support, if they have a family member or somebody that can do it, they can approach the lawyers, they can go to the court, and they can ask to be appointed as the guardian for someone for their money. Either way, whether you go through the public guardian or whether you go through the court, there's a lot of paperwork to be filled out. So again, it has to be someone who has a pretty good sense of money, has a pretty good sense of finances. They have to do a management plan that says, this is what mom gets in, these are the expenses that have to go out, these are the assets, the debts. So they have to do quite a budget up to be able to confirm to people why it is they should be the guardian. And so my role in either case is to confirm, does that person have the ability to understand and appreciate? Because if they do, guardianship is stopped, right? If they can understand and appreciate, we don't put them on guardianship. But if they can't, then somebody is going to become their guardian, whether that's the public guardian and trustee or whether that's a family member. And so those processes are legal processes. So doctors don't do these assessments unless they're also a capacity assessor. But this is where we have to kind of draw the difference between health and medical assessments that are being done in hospital or being done out in the community. They're very different from legal assessments that are looking at who's going to manage the money. So there are lots and lots of places to get more information. The Advocacy Center for the Elderly has a wonderful website with lots and lots of resources on it about financial abuse, about guardianship, about powers of attorney, you name it, it's pretty much on there. The provincial police and the local police, many of the police offices now have dedicated seniors groups, have dedicated seniors or mental health officers, so they're usually useful. The Office of the Public Guardian and Trustee, although it's a scary government organization, they're actually very helpful, right? And so they will help people navigate the system. They will help steer people through. So even if someone's not certain that they need an investigation or that they need a guardian, calling the public guardian and trustee, you can talk to a person and they can help walk you through, here's the options, here's what we suggest you do. Elder Abuse Ontario, of course, we've got lots of things there. Lynn Home and Community Care, it's actually not called Lynn Home and Community Care anymore, but you know who they are, the home care people, and Victim Services. So all of those places have different resources. As I mentioned earlier, I'm quite happy to consult with people and talk with people. Usually when somebody calls me or calls my office, it is about that navigating the system, and it's about, it's more than 20 questions, believe me, it's like 100 questions, because we have to figure out what path somebody is actually on or where they're trying to get. And so it's not as simple as, I need a capacity assessment. It's, well, what are you trying to achieve? What is the outcome that you're looking for? What are the risks that we're trying to mitigate? So there's a lot of different questions that have to be dealt with. And so that's where my practice and my work comes into play, is to try and navigate some of that system and to get them to the person or the people who should be making the decisions, whether that's the client or whether that's the power of attorney or whether that's the guardian. And so informing people sort of who needs to be doing it and when is a big part of what I do. So I'm going to open it up for questions, because that's a lot of material, it's a lot of information. I have provided the slides, so you will have those to look at and to go through on your own as well. But any burning questions? Where did I confuse you?
So this is a common question.
Sure.
Someone's in the community, as you said, there's mandatory reporting in a retirement home and in a long-term care. Mm-hmm. Someone's in the community and you're concerned about them and you think that they're not particularly capable, doesn't seem to have anybody else around. Would you contact the Public Guardian Trustee Investigation Unit at that point, or you're just a concerned neighbour?
Right.
So is that the best route to go, is through the investigation unit?
I would say the investigation unit's probably going to come a little further down the list, because they are going to be looking for imminent serious risk of harm. So if you're just worried, then public guardian's probably not going to do anything. So I would say in that case, you're looking at the elder abuse networks, you're looking at the LIN to get some eyes into the situation, looking at the GAIN teams to try and get them, or the Alzheimer's Society. Basically, we're looking at eyes on the situation. Who can get in there and actually see what's going on? Is there anybody who can actually try to sort things out? Because we need some evidence that they're actually mismanaging. So a neighbor may really have no idea what's going on, but if a social worker or an OT or the nurse practitioner goes in and they're in the home and there's an eviction notice, or there's a foreclosure notice, or there's a hydro bill that's thousands of dollars outstanding, those sort of things are those red flags that we need to be looking for and working with someone, so then we can ask them about it. And in the community, we can't just go and do anything on our own, so we actually have to have something to say to our frail client, to say, this hydro bill says that you owe $3,000. What's going on? How come, can we help you with this? And if you get their consent and you get their permission, then you can sort of go through those next steps to say, is this something that we think she is actually able to do on her own, or is this something that we're looking for a guardian? Is there a power of attorney document anywhere? It's a lot of private investigation work. It's a lot of, is there a lawyer? Is there a daughter somewhere? Is there anything to try and point us in the right direction? And for some people, the answer is no. And so their care team becomes their family who's trying to sort it out. But yeah, I would say we're going to reserve guardianship investigations for somebody that we're quite certain is incapable. We've got evidence to support our belief, and we've got some imminent risk of harm. And so that's anything from, losing their housing is a big one, evictions, things like that. So the other side of that would be if the client may be capable and still able to sort of understand and appreciate, but they may just be overwhelmed. And so it may be more a matter of maybe they can go with their own lawyer. Maybe they can talk to the police and make a statement about something that was stolen from them. Maybe they are able, a capable person can still go through all those usual channels to be able to do that stuff. The guardianship only deals with the people who are not capable. Okay, so you've still got sort of two systems to work through.
Do you have to have the client's consent to do a capacity assessment?
No. So this is always a mystery to people. So I'm an occupational therapist. As an occupational therapist, I have to have informed consent for someone to have a treatment done with them. But capacity is one of those things you can't get informed consent from someone who's believed to be incapable. So we're in an endless loop, right? So for a capacity assessment, we need assent. So assent is they don't throw me out, okay? As long as they don't kick me out of their house, all I need is a foot in the door. So often people will call and say, especially healthcare providers, because they are trying to get consent to refer to me. And I don't need you to get consent. I need you to have the client say, sure, that nice lady can come sit and have tea with me. Once I'm in the house, I have to give them their rights. I have to explain to them what we're doing, what the potential outcomes are, and I have to explicitly tell them, you have the right to refuse. If they say, I'm not talking to you, hit the road, I can't do an assessment. The client themselves is the only one who can refuse. So oftentimes the daughter, the son, the alleged abuser says, no, you're not assessing mom or dad. Well, they don't have the authority to do that. Only the client themselves has the ability to either assent or not assent. But I don't need consent in the way that doctors and nurses and therapists do. And so that gives us, again, that foot in the door to be able to say, because, you can't get consent from someone who's not capable. So, so there is a little bit of a loophole, and it's a little bit of a jiggly thing, but that's, and so often I'll work with elder abuse networks, with situation tables, with teams, because as a capacity assessor, I have that little more wiggle room that maybe the nurse or the therapist or the social worker doesn't have, because the dog catcher can get me in, the fire marshal can get me in. Anybody who can get me in, and the client sits at the table with me, I'm good. So I've got a little more flexibility and swing to get in there.
What happens if there's evidence that they're really not capable? There's lots of evidence that you do get in, and then they tell you to leave.
Then we are in an imminent risk of harm situation. Then we go to guardianship investigations. Guardianship investigations can actually ask a judge for a court order in order to get them assessed. So if there's a court order, then clearly I can go and do that. The other way is if they go into hospital. This one's hard because the docs don't like to do this, but if they have a mental condition and they're admitted to hospital for treatment of a medical condition, there's what's called a Section 15 assessment that the doctor is supposed to do on admission to hospital to a Schedule 1 psychiatric, not the unit, but the hospital itself. So Lake Ridge is a Schedule 1 facility, even though somebody might be on the medical floor of Lake Ridge, they are soldiers. You have to be in for treatment of a mental condition. Doctors don't like to use it, but it's possible, and we do that sometimes, that we can assess somebody without their consent for capacity once they're in hospital. Okay, but we can't force them in the community unless there's a court order. And sometimes we just go back, right? Sometimes it's not that they're refusing the assessment, but it's a bad day, or they're nervous, or they're anxious. So sometimes it's, okay, today we'll just have tea and we'll talk and we'll get to know each other. And is it okay if I come back next week and we'll talk about this? I've only had a couple of people that I've had to go back a second time, and most of them, the thing about incapable people is most of them are really happy to prove that they are capable, even though they're not, right? And so most of them are like, okay, if you are capable, my rights advice is you have the right to refuse. My job is to see either you can do this yourself or you can't, and if you can't, I'm going to get you to someone to do it for you. Well, I can do it myself. Okay, if you can do it yourself, I'll write a report that says you can do it yourself. Everybody will leave you alone. But if you can't, I'm going to get you a guardian. Oh, well, I can do it. This is fine. I'll show you. Okay, we're good. That's all I need. So they're willing to talk to me because they're going to prove to me that they can do it when we know they can't. Okay, so.
Thank you. Yeah, thank you.
Right. Well, thank you so much for having me. It's been a pleasure to work with you, and be glad to see it up on the site so other people can have a go at it as well. And as I say, my contact information is out there, and I cover most of Central Ontario, so I'm all over the place, and happy to talk to anybody by phone, regardless where they are.